You are watching the LemonAid Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hey everyone, welcome back to an all-new episode of the LemonAid Podcast with experienced lemon law attorney Shalev Amar, where we talk about how lemon laws protect consumers from defective vehicles. I am your host, Mike Leon. Today's episode, we're going to clear up whether leased vehicles actually qualify for lemon law protection. A lot of drivers assume, hey, I'm stuck in this lease because I don't technically own the car. So is that the way the law works? Shalev's going to explain all in just a second. And he's going to explain what rights lease drivers have, what qualifies, and how the process plays out when the vehicle technically isn't yours on paper. Shalev, it's good to see you as always. So let's dive into this. I own a finance vehicle. We got leased vehicles, right? And then people that outright buy the vehicle. I'm sure a lot of folks assume that the first two that I mentioned, don't qualify for the lemon law protection. Like, what makes a leased vehicle eligible? Let's talk about leased vehicles first.
Well, in most of the country, leased vehicles are actually covered by the lemon law. However, there's like one glaring state in particular where leases are typically not covered, and that is Arizona. So I wouldn't say 100% of the time they aren't covered. Let me just explain that because it's a little bit complicated, but I'll give you the Cliff Notes version. The reason why leases are typically not covered by the Arizona lemon law is because there was an Arizona Supreme Court decision back in 2006 that said if you lease a vehicle, you technically don't own the vehicle. The leasing company does. You're technically renting the vehicle. And so because the leasing company has title to the vehicle, the leasing company has lemon law rights, but you, the one who are using the vehicle, do not have lemon law rights. And so there is an exception to that, though, and that's if the leasing company gives you the lemon law rights, assigns the rights of a consumer to you under the lemon law. And so the challenge is that most leasing companies are just subsidiaries or part of the manufacturer. And so they're not going to give you those rights. And when it's an independent third party, like a credit union or a bank, then they may give you lemon law rights. What we have advised consumers in Arizona is if you're going to lease a vehicle, only do that if there is an addendum saying that you are the consumer for purposes of the lemon law, otherwise no deal. Unfortunately, majority of people don't know that they have that option. The good news is that in Arizona, they're actually in the process of changing the lemon law statute, amending it to add lessees. A lessee is a consumer who leases a vehicle. So that process could take several months, but it's looking good so far. So hopefully it won't be like that much longer. But unfortunately, at least for consumers in Arizona, they do typically have less lemon law rights.
Yeah. It's good to know. No deal, Howie, if you don't get that lemon law kind of baked in there. So I did mention, though, about finance vehicles. So can you kind of explain back to your overarching point about the states individually, but how does the lemon law process differ? Does it differ between someone who bought the vehicle versus, like you said about Arizona, someone that's kind of renting it, aka leasing it?
Typically, in most states, there is not a difference in substantive rights. By substantive, I mean if your vehicle has had too many repair attempts for a substantial problem or too much time in the repair shop where you're without it within the lemon law period. And typically, the lemon law period is 1 to 2 years, depending on the state, 12 to 24,000 miles. Some don't even have a mileage limitation, but they do have a time limitation. And if it's an unreasonable repair history within that time, you have the same rights. The main difference is sometimes the remedies are a little bit different. In some states where you lease a vehicle, instead of getting a lemon law refund like you can get if you finance, In some states, you can still get a refund minus mileage, what's called a mileage offset, which is typically cents per mile, depending on the miles of your vehicle. In some states, it's set at, for example, in Minnesota, it's 10 cents a mile. In Utah, by statute, it's 21 cents a mile. Other states have a formula where you plug in the price of the vehicle, the mileage, and it spits out certain cents per mile. And typically, it's dependent largely on the cost of the vehicle. So, if the vehicle is, say, $30,000, it would be around 30 cents a mile. Again, depending on the formula, some formulas are slightly different. And if you have a more expensive car, $50,000, $60,000, it would be 50 to 60 cents a mile. And then in states like California, the mileage is only based on the first reported defect that your vehicle ends up being reacquired for. So let's say you have a transmission problem that's repaired 5 times. The mileage in the formula is based on the first time that you brought your vehicle to repair the transmission problem. In other states, the mileage is based on total miles, not the first reported defect. So it really does vary state by state. But in some states, when it comes to leases, you're not eligible for a refund, but you are eligible to get out of the lease without any penalties. And also, you're eligible to get your vehicle replaced and still keep the same lease terms. So you don't have to get a new lease or new financing on the replacement vehicle. But again, there is some variation by state on that as far as remedies.
I'm glad you mentioned that, Shalev, because I should have started at the beginning by asking you what kind of defects actually tend, to get a successful claim in terms of proving that a lease car is a lemon. And is it a little bit different from the purchased vehicles like we mentioned already?
Again, as far as your substantive rights, that's the same. So that what that means is the standard for proving that your vehicle is a lemon is the same. Typically, that means you have to have a substantial defect that is repaired too many times or for too long. So, what's a substantial defect? There is some gray area here, but what's clearly substantial is something that affects the operation or the safety of your vehicle. So, what are we talking about? Transmission that's hesitating, or your vehicle's not accelerating properly, or is causing your vehicle to shake when you accelerate. Brakes, your vehicle is not stopping properly. Obviously, that's a huge safety issue. Engine, engine depends. Sometimes it's safety, sometimes it's not, but anything with the engine is definitely substantial. So, for example, if the radiator goes out, or some kind of engine pump or module with the engine, or the engine's overheating. So that can leave you stuck in the side of the road. It could affect the acceleration and performance of your vehicle. Engine is substantial. What else is substantial? I would say suspension. So suspension means that your vehicle it's basically what your wheels are on. So it means that the vehicle is difficult to control, is shaking, acts weird when going over bumps. That's suspension. I would say steering itself. If the vehicle is pulling to the left or pulling to the right, or is not steering properly, all of these are substantial defects or conditions with the vehicle that would qualify your vehicle as a lemon if they're repaired too many times. And that's whether it's a lease or a purchase or financing. So I would say defects that kind of fall in the middle range, where it's kind of more of a gray area. So I would say they have to happen more times to qualify as a lemon than a substantial defect. Would be things like the navigation system, the sound system on the vehicle, the stereo, things of that nature, where it's aggravating and it's irritating and inconvenient for you, but it doesn't necessarily affect the operation of the vehicle. Now, I would say more minor defects, kind of cosmetic issues, like let's say a cup holder, or you have a trim piece that's loose, something like that. That's unlikely to qualify. So the defects just need to be substantial enough, no matter whether it's a lease or financing or a cash purchase.
So, Shalev, in that regard, and we've talked about this on previous episodes about what should people keep documentation wise. So, you keep bringing the lease vehicle back for these issues. What am I saving? What is the person out there that's listening to this? What are they saving in terms of what's truly important?
It's crucial to always get what's called a repair order or a work order. It's basically documentation, a record showing what was done to your vehicle as far as repairs, whether the repairs were covered under warranty or not, what the complaint was, how long your vehicle was in the shop, miles in, miles out, things of that nature. That's the number one piece of evidence in these types of cases. Absolutely critical, crucial to always get a repair record every time. Even if they tell you cannot confirm or no problem found, you still want to get the repair record, because if the problem keeps happening and you take your vehicle back in again and then a repair is done, then you can argue that the past repair visit is actually a repair attempt that should count towards the law because it was a misdiagnosis. So absolutely critical to get paperwork. Like, if it happens verbally, consider it not even happening. Unfortunately, dealers sometimes lie, or they don't keep proper records, or memories fade. So you always want to get paperwork at the time that the repair is completed or when you get your vehicle back. Either way, you want to get paperwork every single time, whether it's a lease or a purchase.
Dealers sometimes lie. You don't say, Shalev. So let me ask you though, what happens if a manufacturer buys back that leased vehicle? Like, how does the compensation work then for the driver, since they're technically, like, as we've discussed, not the legal owner?
Okay, I would say for a majority of states, it's very similar to if you financed a vehicle. So it's based on the payments that you've made to date, including any down payment. Down payment includes if you got credit for any trade in. And so you add all of that up minus mileage, which again typically comes out to cents per mile. And then they will cancel the rest of the lease. In a minority of states, you don't get charged for mileage, but you also don't get a refund. All they do is cancel the lease. But at least you're still out of the problem. I'm not in favor of that. I think people should get their money back as well.
Right. Well, can I ask you on that front? So if a lease is almost up, but the problems with the vehicle started well in advance of the end date of that lease term, can you still pursue a claim?
Yes, you can, although it depends on the state. If the lease is completely over, in some states, you wouldn't be able to get a buyback or a replacement because you no longer have the vehicle. So in Arizona, for example, courts have ruled that to have a lemon law claim, you have to have the vehicle to give back to the manufacturer. However, in California, you don't have to have the vehicle. You can still get the remedies under the California lemon law. So it does vary state by state. I would say that even if you're not eligible under your state's lemon law, if you have a lease and the lease is ended, you could still potentially get compensation under the federal lemon law. It's called the Magnuson-Moss Warranty Act, and it applies to all warranted consumer products that cost more than $25. So obviously that includes motor vehicles, cars, motorcycles, RVs, off-road vehicles. It actually, the federal lemon law covers a wider range of vehicles than most state lemon laws, because most state lemon laws apply to vehicles that can be driven on public highways. So that obviously, or that are primarily designed for transportation on public highways, that obviously would not cover a boat or an ATV. But the thing under the federal lemon law is you can't get a buyback or a replacement, but you can get cash compensation. So that's better than nothing. And the reason is because under the federal lemon law, the way that damages are evaluated, and damages just means the financial harm that you suffered, is you overpaid for the product given the problems that you've had. Typically you leased new, but you got the equivalent of used and run down, which should have cost you substantially less. And so you should get that gap. Again, the easiest way to understand it is new versus used. The other way to get damages under the federal lemon law or compensation for your loss is what are called incidental and consequential damages. That's basically a consequence of the warranty being breached. The warranty is breached because repairs are not done in a reasonable number of attempts or in a reasonable time. So the main type of incidental and consequential damage for that is what's called loss of use. So basically, the time that your vehicle's in the repair shop, because you're paying on the vehicle, because it would cost you money to rent a vehicle, you should get the fair rental value of a comparable vehicle for the time that your vehicle's been in the repair shop. So that's another way to look at damages as far as what you could get, even if the state lemon law is timed out. Mm-hmm. And sometimes manufacturers, companies try to argue, well, you don't have the vehicle anymore, you shouldn't be able to get anything. They might be right when it comes to the state lemon law, depending on the state, but they're actually dead wrong when it comes to the federal lemon law. Because the federal lemon law, it's kind of interesting. It doesn't specify the exact compensation that's possible for breach of warranty. So what the act does is it incorporates state warranty law to determine damages, the type of compensation that you can get. And under state lemon law, the main types of damages, which is you didn't get what you paid for, is called diminution in value. The vehicle wasn't worth what you paid for it. That is based on what the vehicle should have cost when you acquired it, if it was foreseeable that it would have the defects and the repair history that ended up happening and ended up having. And what should it really have cost if it was the equivalent of a used and rundown vehicle? And that's based on a UCC section, which stands for Uniform Commercial Code, which every state has a version of the Uniform Commercial Code. And all of them say that those damages, that type of compensation, again, depends on when you acquired the product. And so even though companies might try and argue that like, oh, your lease is up, you can't get anything, that's just legally incorrect.
Yeah. Save your documentation, hit up a lemon law attorney. I know one. Shalev, thank you so much for the time, the insights as always. I appreciate it, my friend.
You're very welcome. Glad to be with you again, Mike.
That's it for today's episode of the LemonAid Podcast with attorney Shalev Amar. If you're dealing with a defected lease vehicle, listen to me, okay, right now. I'm going to give you some websites right here because enough is enough. And if you go to Arizona, Oregon, Washington, Utah, Colorado, Minnesota, or New Mexico, lemonlawadvocates.com, or if you live in California, lemonlawadvocate.com, or Nevada, lemonlaw.info. You're going to be able to connect with Shalev and the team, or you can call 866-904-2627 for a free lemon law evaluation. Amar Law Group has a fair, free guarantee. You never pay more in attorney fees than you recover for out-of-court cash and keep resolutions. Do me one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. As always, I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.